They say you can't beat City Hall, and for the most part I grew up believing that. Believing that the cards are somewhat stacked against you if you're not rich, famous, or a political figure. I believe standing up to the system was nothing more than a waste of one's time and money. But there are times when something happens to someone or something that you care about that are so unfair or outrageous that the anger inside of you boils over and you say, "Whoa, enough is enough. I'll see you in court." Such was the case for our family, which started with an incident in December 2011 when, with only 5 months remaining in college, our daughter was kicked out. We would like to share with the public our experience of what happens when a common person stands up to big government. We will break our true story up into several parts. We would like to start off by saying that our daughter filed a lawsuit against a public university in 2012 and then refiled in 2013 after hiring a different attorney. The attorney representing the university requested a summary judgment, and only days before the pretrial was to begin, this request was granted. Submitted as evidence for the university was information that, according to our attorney, was nothing more than hearsay. That is, the sworn affidavit submitted was testimony from a witness who did not have direct knowledge of the fact asserted, but had been told this information by someone else. And so, without questioning the witness's testimony or allowing our attorney to cross-examine the witness or having to prove the authenticity of the submitted documents, the judge overseeing the case ruled in favor of the university. And so, after preparing for almost a year and a half of trial and spending over $11,000 in legal fees, our daughter was never allowed a trial, nor was she able to face her accusers in a court of law. Now, I'll admit, law isn't our profession, but from what we've read, in order to succeed in a motion for summary judgment, the person requesting this must show that there are no disputed material issues of fact, and that the movant is entitled to judgment as a matter of law. Well, there was indeed disputed material issues of fact. Some university faculty was claiming that our daughter had committed some very serious offenses, and our daughter was denying all of these accusations. Therefore, this doesn't take a rocket scientist to know that this suggests that a summary judgment never should have been granted. But, like I said, law isn't our profession. This was just one of the many unbelievable occurrences involving this case. We ask that you please review our entire story, and if you find things that scream unbelievable, we ask that you share our story with as many family and friends as possible. For now, we're going to keep the name of the university and all involved private. In 2011, our daughter was enrolled in an accelerated nursing program at a public university and doing extremely well, having already earned 3 degrees, an associate's in science and art, and a bachelor's in health science. It was just a matter of months before she would graduate with her degree in Bachelor's of Science of Nursing. Having completed 12 months of classroom lectures, homework assignments, and clinical evaluations, our daughter had completed the final evaluation on what would have been her last patient in this program and looking forward to Christmas break. After the break, she was excited about returning to complete her final 5 months of shadowing before graduating from the nursing program. But this was not to be. On December 8, 2011, our daughter was called into the office of the Director of Undergraduate Programs and handed a letter dismissing her immediately from the program on the grounds of alleged misconduct. The letter accused our daughter of 3 things: endangering the welfare of a patient, falsifying a patient's medical records, and lying to her instructor and the assigned nursing staff. Our daughter was informed that her last patient, who had been introduced as a registered nurse and a clinical instructor, supposedly claimed our daughter had not completed all required testing on her and her baby. Therefore, the information noted in the patient's chart was considered falsified. Our daughter strongly denied these allegations and asked to have a meeting with her instructor and the patient. However, this request was denied. Because our daughter was not given her due process, she did not have an opportunity to be heard and was immediately expelled from the nursing program. We immediately hired an attorney. In following the university's student handbook, we requested and were granted a hearing. On January 26, 2012, a hearing at the university was conducted before the Students' Grievance Board. Present also were other CSU faculty who were accusing our daughter, along with their attorney and the mediator. Interestingly, not present at the hearing was the instructor who was overseeing our daughter on the day of the alleged incident, and the patient in question, who did later admit that only hours before our daughter started performing the evaluations had taken 2 Percocets. The patient also admitted that she was friends with this instructor and that the instructor had asked her to write up the complaint about our daughter. During the hearing, our daughter's accusers submitted a 7-page document detailing the alleged incident. 1 page was the handwritten statement provided by the patient. And during the hearing, which according to our daughter had been audio taped, our daughter explained in detail of an incident that had occurred 6 months prior. This incident, we believe, is the true reason these serious allegations were made against our daughter and used to justify her dismissal from the nursing program. In June 2011, our daughter met with the dean of the nursing program and explained that one of the clinical instructors was not assisting her with the charting system. The dean informed our daughter that it was her responsibility to learn the charting system with the instructor's help or without. Our daughter next contacted the ombudsman of the university to assist her with this issue. The ombudsman contacted the dean of nursing directly and was instrumental in getting our daughter placed in a different clinical group with a different instructor. The dean of the nursing program soon summoned our daughter to her office and informed her that by her going to the ombudsman, that was very embarrassing not only to her, but to the entire school of nursing. And 6 months later, after successfully completing all required classroom assignments and after completing the final assessment on her last patient, our daughter was blindsided with a letter of dismissal. Our daughter also informed the board members that the instructor who had initially refused to assist her with the charting system was no longer employed at the university. And when she asked why the instructor, who was present at the time of this alleged incident, was not present at the hearing today, the faculty members told her that this instructor was busy. On February 3, 2012, the Students' Grievance Board issued the following findings. 1. Our daughter's dismissal was in fact unwarranted, and 2. Our daughter was not afforded her due process. The Students' Grievance Board also noticed that they sensed some animosity between the faculty and our daughter. We were informed these findings were to be sent to the university's president. We were ecstatic. We had hopes that our daughter would be permitted to return to the university to complete the remaining of the program and graduate with her class in a few months. Unfortunately, that excitement was short-lived. The president of the university refused to reinstate her, siding with the School of Nursing. And so, having completed 12 months of the program and with only a few months remaining, our daughter was kicked out of the class and no longer permitted to participate in the program. And so, we will conclude our story at this point. And while the experience of being kicked out of the program on trumped-up charges was certainly bad enough for our daughter, we hope you will tune into our next episode when we discuss in detail the true tragedy of the story, our experience of what it's like when a common person tries to get fair treatment in our judicial system when suing a state-protected agency. Thanks for watching.